Good morning. I'm recording this video to explain some principles about priority of trademark rights in the United States. And I thought there's a lot to say. I thought this would be easier than trying to type it all up. I'm going to explain some principles, and then I'm going to go through a list of six examples based on the questions that were posed in this email from last year. So trademark rights in the United States are based on a combination of two things: use and filing. The basic principle is that trademark rights arise through use, and so you can have trademark rights even if you don't have any trademark registration. We call those common law rights. When you file a trademark application, the law says that you have constructive use throughout the country as of the filing date, provided that you eventually get a registration for that mark. So, for example, if you suppose that one person is using a trademark in a geographic area, and then later on another person files a trademark application, the general idea is that the first person is going to be limited in their rights to the geographic area where they were using the mark at the time the second person filed the trademark application. Because the moment that second person files a trademark application, their rights fill the rest of the country, everywhere except where the pre-existing user was already using the mark. Again, that assumes that the second person actually gets a registration. If you file an application but it hasn't matured into a registration, and someone opposes it, the rules can be a little more complicated, but we'll just assume that the second person has a registration for the moment. So that's the basic principle, is that you file an application, you have immediate constructive use, meaning the law pretends that you actually use the mark everywhere in the United States as of that date, or as of the priority date if you have a claim to foreign priority, that gives you an earlier priority date. Now that's interesting because if you're filing under Section 44E or Section 66A of the U.S. Trademark Act, meaning based on a foreign registration that we submit to the U.S. office, or through the Madrid Protocol, which is essentially the same thing, based on a foreign registration, you're asserting that you have you're asserting that you have the intent to use the trademark in the U.S., but you're not confirming that you have that use actually happening. And yet, when you file the application, you still have constructive use. Your rights begin as of the date that you filed. And if someone starts using the mark after that date, you still win priority. So, I've said to many people, if you're a foreign company, if you're outside the United States, you have this great advantage because you can get a registration without using the mark in the United States. Companies in the U.S. can't do that. But that's based on the intent that you have to use the mark in the United States. A couple of points about what I've said, a couple of further sort of general principle points. When I say that you have rights in the geographic area where you're operating, the question is, how big is that geographic area? And that's what we fight about. That's what the disputes are about. So suppose that a first party starts to use a trademark in Los Angeles. Well, let's say Pasadena, a small city next to Los Angeles. It's a little smaller than Los Angeles itself. They're using the mark in Pasadena, and then later on, another company files an application to register a very similar mark. At the time they file, they immediately have constructive nationwide rights. And so this first party has rights in Pasadena, the second party has rights everywhere else. Now they go into a dispute. The question is that they're going to argue about is, what is the geographic scope of the rights of the first party? Is it Pasadena, one little city? Is it Los Angeles County? Is it the metropolitan Los Angeles area, which could go from Ventura all the way down to San Diego? I don't know how many millions of people. Is it the state of California? Now, if I'm representing the company in Pasadena, I'm going to say, well, we get everything east of the Mississippi River, and you can have everything west of the Mississippi. We get, California said, we get west of the Mississippi, and you guys can have east of the Mississippi. And the other side is going to say, no, you get Pasadena, period. And the argument between those two extremes is where the dispute will play out. What the court would decide and what the settlement will come down to is based very much on the facts of a specific case. These are very fact-intensive questions, and they vary based on what's actually being done. So 2 examples, and I'm not giving you case law here, but just sort of theoretical examples. If the company in Pasadena is a hair salon, we can imagine that people who go to a hair salon are normally going to travel no more than, say, 5 miles to get their hair cut. That would be kind of, and we would put in evidence, to try and show this if we were on the side trying to limit the geographic rights. We would say it only makes sense that this hair salon should have rights in Pasadena based on, their channels of trade, the industry that they're in, the history of who their customers are. Okay, we're going to limit it. Suppose that the company based in Pasadena is a plumber. Now, plumbers, they go out to their customers, and my impression is that a plumber would often, depending on the size of the business, they would often go 50, 75 miles away from their office to visit customers' homes. So in that case, the natural zone where they might claim rights in their trademark, maybe it covers the entire Los Angeles metropolitan area, a circle of 75 miles around their office, or if they have a couple of offices, So it could reasonably be asserted that their rights are much broader. Now, what if they can also show their customer database, and the plumber is perhaps more likely to have customers who are actually, located within that larger geographic area. The hair salon, probably less likely, although they can also put into evidence, who their customers are and how broadly dispersed they are to try to say, we own all this area. That's where our rights are. Now suppose that the company in Pasadena is a software company, and they've been, maybe providing an online service. Who knows? They're hosting websites, or they're providing video streaming services on some topic, and they have clients. They have people that they can document, using Google Analytics and so forth, that have come from all over the country. They've got clients in New York, Florida, Chicago, Seattle, Los Angeles, and other places. That company might reasonably say, we own the whole country, or we own, all of these major metropolitan areas. And if they can document that, then someone who's coming against them might have a really difficult time, because the common law rights of the first party to use the mark may actually kind of fill the whole country. And so the later filer of a trademark application may be left with almost nothing, okay? And that's an increasing issue, obviously, with everyone going online, because you're selling to people all over the country. Makes it much more important that we do research into potential conflicts based on common law rights before we, file as applications. That research is obviously harder to do, although most people are online now. So that's the geographic issue. There's a system within the Trademark Office where you can file what's called a concurrent use trademark application. And this is the sort of the proper way to deal with this. If you want to file a trademark application and you discover that a party in Pasadena, California is using a similar mark, and you want to occupy the rest of the country, you want rights everywhere but Pasadena, but you sort of acknowledge that, or you're pretty confident that they have those rights in Pasadena, you don't want to dispute that. What you would do as the second party is you would file a concurrent use application for your trademark. And in that application, you define the fact that you're not claiming nationwide exclusive rights in the trademark. You're claiming rights in the defined geographic area that you list in the application. So in this case, maybe you carve out Pasadena, or you carve out Los Angeles County, whatever you're willing to give up. And then after your application has been examined, it goes to the Trademark Trial and Appeal Board in a manner very similar to an opposition proceeding or a cancellation proceeding. And the board then contacts the other party. It's a two-party proceeding, and the TTAB is going to decide the geographic split of the country. And assuming that that goes well, you're going to get a registration issued with a geographic restriction in place. The truth is that those are extremely rare. What everyone actually does is they say, no, we're not conceding that anyone has any rights. We're filing a regular application, and if they come back at us, we're gonna fight them. We're gonna say they don't have any rights, or they're gonna have to prove that they have rights in Pasadena in a cancellation proceeding, and then we will concede the limitation on our rights. But a concurrent use proceeding, extremely rare. Okay, another issue that you raised that I want to address is the 3-year rule. Now, the 3-year rule states that if you have not used a trademark for 3 years, you are presumed to have abandoned it, or presumed to have no intention to use it if it's an intent to use registration, like under the Madrid Protocol. But that 3-year rule really doesn't come into play in most cases. It's not really that important. And the reason is that the 3-year rule simply changes the presumption of the law to move the burden from one side to the other. So let me see if I can give an example of that with some detail so you can see how that would work. Suppose Party A has a registration, a trademark registration through the Madrid Protocol. They register it on January 1st. The registration was issued on January 1st, 2020. Someone comes along January 1st, 2022, so 2 years after registration. They see there's a conflict and they want to attack the other mark. They're going to file a petition for cancellation of the mark that was issued in 2020, and they're going to allege that the trademark owner, the registrant, does not actually have an intent to use the mark. Now, they don't have to, actual use isn't an issue because it was issued under Madrid, so they don't have to have used the mark yet, right? They just have to have an intent to use the mark. Because it's less than 3 years, it means that the party that files the petition, the attacking party, the plaintiff, has the burden of proving that the first party has no intention to use the trademark. Okay? And I'll talk about the burden or the evidence and stuff in a minute. Now suppose a second case. Registrant gets registration issued January 1st, 2020. The second party comes along January 1st, 2024 and does the same thing. They want to cancel the first registration based on, there's no use and there's no intention to use. I shouldn't say non-use. They don't have to use it. But they say there is no intention to use, therefore it's presumed abandoned, and we should get to cancel it. Now, the difference between those two situations is, in the first case, the plaintiff has to prove that there's no intent to use the mark. In the second case, after the 3-year period has elapsed, the registrant has to prove that there is an intent. So it's just a burden shifting from one party to the other. Now, that's legally important, but in practicality, it usually doesn't make a big difference. The second party is still going to petition to cancel. Most of the same evidence is going to be presented, which I'll talk about in a second. It's just a matter of who's going to make the argument, and if one side doesn't meet its burden, then the other side wins. So in the first case, if the plaintiff doesn't take the actions to say, here's the evidence, it's clear that there's no intent to use, then if they don't meet that burden, then the defendant wins. The registration stays. But in the second case, the defendant has to prove that they did have an intent. And if they don't meet that burden, then the plaintiff will win. Now, when I talk about intent to use, what does that mean? The U.S. courts and the TTAB in recent years have said intent to use a trademark in the U.S. can't be sort of this generalized idea. We filed an application, so obviously we intend to use the mark. You need to have contemporaneous documentary evidence that shows an intent to use. So if you are a European registrant and you've got a registration for 10 different items, 10 different goods in a class, and you need to prove that you have that you have an intention to use the mark with those goods in the United States, what you want to submit as evidence is things like, and I'm just kind of brainstorming here, you want a record that you attended trade shows in the United States during the period when you were trying to get distributors. You want emails with potential distributors where you say, where your email to them, the email exchange is, we're trying to find a distributor in the U.S. for our products under brand X. Would you be interested? We could send you a price list, and the other side's, back and forth. Internal memos where dated obviously before a dispute arises, where the president of the company, the general manager, is saying to his staff, we really need to get into the U.S. market. Could you please investigate potential distributors? Our competitors are in the U.S. We should be there soon. How soon can we get there? Internal PowerPoint presentations where the United States is listed as a target market. Okay, all of this is hard evidence that it wasn't just sort of this speculated thing, oh, we should go in the U.S. sometime, but it was really contemplated as of a certain date in a manner such that it was written down. That's the kind of evidence that if someone attacks your registration and says you didn't have any intent to use this, you send back those emails and those discussions with distributors, those internal documents, and you win, because that shows we had the intent. You don't have to be using it yet, until it's time for the declaration of use 6 years after registration. Everyone has that obligation. But that's how you can defeat that, whether the burden is on you or the other side, depending on the 3-year rule. But again, the 3-year rule doesn't come into play much, because it's just that, who has to write that detail in their brief. But the evidence that one side or the other is going to need is going to be the same. So if you're the registrant, you can get that registration without use, without a statement of use. You base it on that EU registration, that German registration. But you're well served if you maintain the documents that show intent to use, so that if that's ever needed, it's like, here it is, we've got it, and that'll get you through any dispute. And that will be relevant when I talk in a few minutes about the danger of an intent to use registration in the U.S., based on foreign registration, based on the Madrid Protocol. So those are the main things I was going to say on that. There was one other point. Oh, U.S. law used to have a rule called the Medinol rule. It was a case called the Medinol case, and it was very strict about fraud on the PTO, like making a false statement where you make your declaration and say we have intention to use the mark on all these things, and if there was anything proven false in that, then they would cancel the entire registration. So the really high level of risk. A few years ago, I guess might have been 10 years now, but the rule now is under a case called the Bose decision, and it's much more lenient. The penalties are less severe. So, for example, if I have a European client that's filed an application in 5 classes, and they list a lot of goods and services, if that registration gets registered, if that registration is then attacked on one of these bases for no intent to use, and suppose we can establish intention to use the mark for our core goods and services. Maybe we're selling clothing and jewelry, but we can't prove that we have an intention to use telecom services in Class 38, a class that I often see coming from Europe that we don't use much in the US. Under the Bose decision, the court or the TTAB is only going to cancel Class 38, or maybe just a few services in Class 38, depending on, what the skills of the other attorney or what was attacked. But they're not going to cancel the entire registration. So the level of risk is lower than it used to be. That said, I mean, I have had applications coming from the EU where I have a 10,000 word description of goods and services. It's not that uncommon to have a 2,000 word description of goods and services. Because they'll just take the EU application and dump it in the US Trademark Office. And you can get that registration, but it's asking for trouble. The examiners hate it. It's a lot more work to get it through with the revisions and so forth. But it leaves you open to all these problems, because whenever a US lawyer sees a registration like that, their immediate thought is, I can attack that all day. I can tear that apart. And even if some of the items will remain, you've got this big old list, but you're actually selling 2 items, maybe the entire registration won't be canceled. And in the end, the registrant will be left with, a registration for 2 items. And so, that's fine for them. But in the meantime, they've spent $50,000 in legal fees to get through the cancellation proceeding, because the plaintiff was trying to use it as a pressure point to say, you're going to cooperate with us, you're going to consent to our registration, you're going to settle on terms that we like, or we're going to keep hammering you at the Trademark Office to try to cancel your registration. And so you're just much more vulnerable. And that's the problem I'll talk about in a minute further. So those are the general principles. It gets really kind of into a lot of fact examination as to the intention, as to which goods and services should really be there. This issue of fraud is the big issue, and then the geographic scope. How wide should it be? Just to give one example, we had one last year where there was a coffee shop in one town in Ohio, and we had a registration. They had prior common law rights. So it was very similar to what I've described to you. It's not an uncommon situation. And they literally said to us, we get east of the Mississippi, we get this half of the United States, and you get that half of the United States, based on one coffee shop in a small town in Ohio. And that didn't go over very well with our client, and we ended up winning. But that's the discussion that ends up happening all the time. So I'm going to go through these examples from the email that you sent last year, and a few more points will come out, although I'll be building on the details that I've already explained, maybe with a few more conceptual points. So person A files an international registration designated the United States. So because it's through the Madrid Protocol, it's on an intent to use basis. Priority date of 1st of February 2019. There's no use of the mark, but priority date of 1st of February 2019. Person B files a similar U.S. trademark, overlapping goods and services, based on 1st of February, with a priority date of 1st of February 2020, 1 year later. Who has older rights? The international registration absolutely has earlier rights. The second party had no prior use, so they have no common law rights. The international registration has constructive use throughout the United States as of the filing date, 1st of February 2019. So the second party has nothing, okay? So that was pretty easy. Well, the question here, can one to whom the earlier rights are to be granted block the other, or do both trademarks coexist? They don't coexist. The later filing should be rejected by a trademark examiner. But if the marks are not identical, if the trademark examiner is not very good, then if the second application is allowed, the first registrant who has the 2019 filing can oppose it and win based on priority. Now again, we're assuming, as the question says, that the marks and the goods are confusingly similar, so that the only issue is priority. In that circumstance, if we're trying to win, obviously we argue that there are differences in the marks, there are differences in the goods and services, and so they can coexist. But if the question is priority, the international registration wins in that case, no question. Okay, example number 2. Person A files an international mark in the United States. Priority date 1st of February 2019. No use of the mark in the United States. Person B files an identical or similar mark based on intent to use and started use, let me restate that. Person B files February 1st, 2020 and starts use February 1st, 2021. So first party 2019, so you can see my hand, first party 2019, second party files in 2020, starts use in 2021. And again, who has the older rights, who has priority, who can stop who? Clearly, the international registration, the 2019 party, because of the constructive use rule, wins. Okay, the second application filed in 2020 should be refused if there's similar marks. If it's not refused, the first party, 2019 international registration, can oppose the later application and win, or if it somehow slips through, the owner of the international registration didn't see it and didn't oppose, and it gets registered because the examiner was asleep at the switch. So now we have the two conflicting registrations. The earlier registration can then petition to cancel, even if it's after the second party had used the mark. So that may not have been clear. First party, European applicant, gets a registration with a priority date of 1st of February 2019. A second party somehow slips through and gets a registration with a priority date 1st of February 2020, and they've actually used the mark starting in 2021. And the international registrant, who has priority in 2019, still hasn't used the mark. The international registrant from 2019 will still win in a petition to cancel based on the constructive use that's effective as of February 1st, 2019, the day of filing the application. Okay? Because the second party would need to have had use before the filing date in order to have any rights that it could go against that. Now, in one of the later cases, one of the later examples here, I'll talk about the danger to the international registrant. So he should win, but there's a caveat there. Well, maybe I should explain that now, so I don't forget. So the 2019 registrant from Europe should win in that case. They will win, but what happens is the second party, that started using in 2021, they're being attacked. Petition to cancel was filed against them, and this European company says we have rights going back to 2019 under the constructive use rule. We have priority. It's cut and dried, no problem. But what the second party will do is they'll look at that that registration, that U.S. registration owned by the European company, and in 9 cases out of 10, there will be there'll be flaws in the 2019 registration. And so, and I'll explain what I mean by flaws. And so the later U.S. trademark owner will attack the European trademark owner based on those problems. And so the European owner petitions to cancel the later trademark owner, and the later trademark owner does a counterclaim against the European registrant. And that does a couple things. First of all, it makes it so that the European party that petitioned to cancel, they can't just end the case. They can't just withdraw and say, the expenses are too high, we're gonna drop this case. They're locked together now, and they can't end the case unless the other party agrees to it. So now they're in this, wrestling match together, and the other party has to agree before you can withdraw. So that's a very different situation to be in. Also, as I've kind of described, the first party that has the the EU, I'm misstating, the US registration owned by a party in Europe, if it has this big long list of goods and services, the US trademark owner that's later, that does not have priority, is going to look at that and go, we can attack that all day long. We'll say that they committed fraud on the PTO when they filed the application. We'll say the mark's abandoned as to most of the goods, because they've listed 75 items and they're selling one thing in the United States. We've done our research, we see one thing. And so we attack it, and again, maybe in the end, the European owner of the priority registration, maybe they'll end up with a registration with one item left and that's what they're selling. But it's going to cost them $100,000 to get to that point. And so because of that risk, they find themselves at a real disadvantage strategically because of the terrible cost of disputes in the United States, even at the trademark office, not going to federal court where it's double or triple as much, but just at the Trademark Trial and Appeal Board. Average cost last time I looked was about $80,000 for a full opposition proceeding. And so if you're a European company and we say to you, well, you're going to win because you have priority, there's no requirement that you use the mark yet. The burden's on the other side to prove that you don't have an intent to use. But the fact is, you don't have an intent to use for most of these goods. So you're going to spend $50,000 to $80,000, maybe more. You're going to win, but it's going to cost you a fortune, and then you'll be left with a registration that has one item in it. So even though you're going to win, it's this strategically difficult situation that they're in because of the big long list of goods, maybe because they didn't keep evidence of their intention as to the U.S. market. So that kind of covers the issue. The rest of these may be fairly straightforward now. Third example. Person A files an international registration designated the United States. Priority date, 1st of February 2019. No use of the mark. Person B Person B uses a similar mark beginning 2020 in one state, but has no trademark application filed. Who has older rights? If it's person B, can person B block person A? Okay, so person B, who began use after the international registration priority date for the U.S. portion of the international registration, person B has no rights at all. Person A, who filed in the U.S. in 2019, constructive use as of February 1st, 2019, they have the rights. Person B comes along and begins using a similar trademark after that date, they have no rights. Person A can go to court and get an injunction and stop them from using that trademark, with the caveat that if B has money, B can counterclaim against A and try to attack their trademark registration. They have priority, they have all the rights, but if it's subject to attack for these issues I've talked about, then it's still a problem. But on its face, A wins based on the U.S. registration, based on an international registration with no use in the United States. Doesn't matter. Example 4. Person A files an international registration designating the United States. Priority, 1st of February 2019, no use of the mark. Person B uses a mark beginning February 1st, 2020 in the entire United States. So this is the same as example 3, except the use is throughout the United States. Doesn't matter. Person A has rights back to 2019. Nothing that party B does after that can get behind the priority of person A. So with the caveat about the danger of a counterclaim, party A has priority and will win that case. Okay. Example 5, person A uses a brand name since February 1st, 2020 in one state of the U.S. Person B files international registration designated in the United States with a priority date of 1st of February 2021 with no use yet. So this is the Pasadena situation that I described at the beginning. A user in the United States begins use in one state, and then a later filed application has priority in the rest of the country. So person A, we're going to use Pasadena for this example, repeating what I said before. Person A continues to have rights in Pasadena, in the one area where they were. Person B gets the rest of the country. Now, procedurally how that works, it's interesting. The Trademark Office doesn't know about person A using the mark without registration. So the Trademark Office is going to grant a registration with no restrictions to person B based on the international registration. It will cover the entire United States. So on its face, the rights of person A and the rights of person B are in direct conflict. Person A had use in Pasadena. Person B has a registration that includes all the United States, including all of California. So that just coexists until one of them decides to fight. Now, when they decide to fight, person A, who has common law rights in Pasadena, can petition to cancel or limit, they usually petition to cancel, the registration that was issued to I'll say the European registrant, okay? The person in Pasadena will say, I have prior common law rights, this registration must be canceled. And if that goes to the end, then they'll end up dividing the country. They'll end up limiting the scope of the international registration. And again, it's going to be to Pasadena, to Los Angeles, to the metro area, to California, to west of the Mississippi. We don't know. It depends on the evidence that the earlier user in Pasadena can put forward. But, that's how it works. The second party who has a registration but no use could file an action against the first party to stop their use. And that's a bad idea. We see that once in a while where someone with a registration will discover someone who's been using a similar mark for a long time, and they'll send a cease and desist letter. We have this registration, we found you using a similar mark, you have to stop. And the person who's using the mark says, we've been using it for 10 years before you filed your application. You get out of the market. And that's really embarrassing, if you're the one that sent the letter. Because there's nothing, if the use has been continuous from the first party in Pasadena, there's nothing that the trademark registrant can do to deprive them of their rights in Pasadena. Now, it's a question of how big those are. Pasadena, all of California, but some scope of rights, those exist, and if they keep using the mark, the registrant can do nothing about it. They could decide, the registrant, the later registrant, could decide to file an action, a court case. It wouldn't be at the Trademark Office because the other party doesn't have registered rights, so it would be at a federal court. They could decide to ask for a declaratory judgment, meaning we're asking the court to establish the scope of our rights. It's a little different procedure, but then the court would be asked to decide, how big are those rights? Like a big company might want to do that to say, so that it was not an unknown. If you had a big food company and they have a brand of food and they're trying to sell it nationwide, and they want to know, where can we use this brand and not be an infringement? Like on their financial statements, they don't want to have to list, there's this unknown legal risk that could come back and cause us trouble and expense. And so they can proactively ask the court to decide what are the scope of this other party's rights. And once we know that, then we know where we have to stay out of. We have to use a different brand in that market. We can't sell in that market to the grocery stores in that area, whatever. But they could try and define that judicially to remove that, that danger. Okay, sixth example. Let's see. Sixth example. Very similar, I think, here. Person A uses a brand name in the entire United States. I need to get the date off of that for this story. Person A uses since February 1st, 2020, throughout the United States. So maybe this is an online business. You know, they effectively have clients in every major metropolitan area in the country, or they can document uses in all 50 states and, 5 territories, Puerto Rico and Guam. Person B files an international mark designating the United States, priority date of February 1st, 2021, 1 year later. No use of the mark yet. So party B is going to get a registration because party A's rights are not known to the trademark office. They don't consider them. But party B's trademark registration is useless. It's subject to cancellation in its entirety by party A. So if party A learns about it, let me see how this would work. If party A learns about the registration of party B, usually when they kind of grow up and say, oh, we need to get a trademark registration for our brand, they hire a trademark attorney, or they look on the register and they say, oh, there's a conflicting mark already there, already registered. They look at the details, find that the priority date's a year after they began use, and they know that they had use, throughout the United States. They file a petition to cancel that registration. And the attorney for party B, the later registration that does not have priority but has a registration, the attorney looks at the evidence and goes, you're going to lose. Change brands immediately. See if you can work out a timeline for a smooth transition, but they have rights throughout the United States. You can't sell anything anywhere. You have a registration, but it's useless because of the common law rights of the other party. Now, depending on the size of the registrant, the person who doesn't have priority, the European company, depending on the size, they could push the issue, right? They could force the other party to provide all the evidence and go through discovery and so forth, and impose a lot of costs on them. And they could do that to try to get some kind of settlement, where you might say, look, we're selling similar goods and the marks are similar, but we only sell through the specialized markets, or we always sell with this logo that's highly distinctive. We want you to allow us to coexist. And maybe the person who should win the case will say, we can't spend $100,000 on this. We have rights everywhere, but we can't bear the legal expense. And so we'll enter a settlement agreement. That's the unfortunate reality of legal procedures in the United States. Sometimes the party that should lose ends up kind of winning because of the terrible expenses that are part of the system. But I hope what I've said is clear about who has rights and how that plays out. I think that I painted a pretty complete picture of priority and the rights and the strategic dangers to going with intent to use and, well, not really intent to use. Intent to use is fine. The danger is if you have a giant list of goods and you can't substantiate that you really intended to sell all the items in your application, because that's when you're subject to counterattack, to counterclaims in any kind of dispute proceeding. But it's a very complex area of the trademark law, obviously, but it's probably the most critical area. This is where, I don't know if it's the majority, it might well be the majority of the disputes that I'm involved in use these fact patterns, where someone's common law rights predate an application by a second party. And sometimes it's like, we started here, and then we started here, and then one party filed here, and the other party filed here, and we're trying to sort out, the geographic rights of each party at a different date, and what evidence do we have to support that? And so, it's very common for two U.S. registrants or two U.S. trademark owners, common law or registered owners, and then you throw the the international issues in with the intent to use marks, the international registrations, it just gets a little more complicated because of the intent to use factor and the ability to have priority date based on the Paris Convention. But the issues of having that priority date based on filing, intent to use, and documenting it, those are really very similar. And I would say the international registrations are treated, I think, very fairly, very well based on that rule of what the filing date does for you. So hope that's helpful. Let me know if I can provide more information.